I'm Vaughan Hattingh and a director of MDA attorneys. Today I'm joined with one of our associates, Zodwa, Malinga, and we're talking around adjudication, and more particularly the initiation of adjudication proceedings under the contractual adjudication process that we work with in the standard form construction contracts, including the JBCC suite, the GCC suite, and the FIDIC and NEC contract documentation. A question that we deal with regularly is what documentation we have to put forward to initiate adjudication proceeding. In the United Kingdom, where we have a statutory form of adjudication, the content of the initial notices is prescribed and detailed under the scheme and the applicable legislation, whereas in the contracts that we deal with, we don't have a prescribed, either a prescribed form or the prescribed content that we have to put forward when we initiate these proceedings.
Mm-hmm.
So we're going to be looking at very briefly what first step in initiating an adjudication, and to protect your position in that adjudication, what needs to be included in those initial documents, and particularly the first document that we file to kick off the adjudication proceedings.
My question would be, why do you have to be meticulous in preparing your notice of dispute?
Each of these contracts require that if a dispute is or has crystallized and a party wants to refer that dispute to the adjudication procedure, that a notice needs to be given. It's necessary in order to kick off the process and to initiate the adjudication. The question is why we have to be meticulous. Firstly, when we declare a dispute under either of the forms of contract, a dispute has had to have crystallized. And in order for there to be an adjudication, there must be something to adjudicate, firstly. And secondly, when an adjudicator is appointed, the adjudicator requires a jurisdiction. The adjudicator doesn't have jurisdiction inherently. Jurisdiction needs to be given by agreement to the adjudicator. And the more detailed one is and the more meticulous one deals with the dispute and ensures that the dispute is unequivocally crystallized, the less room is open for uncertainty as to what is in front of the adjudicator, firstly, and secondly, more importantly, what the adjudicator's jurisdiction is. In other words, what does that adjudicator have to deal with? But from that point of view, I think it's imperative that we are as detailed as possible, and enough attention is given to detail to remove any uncertainty that A, there was a dispute or is a dispute persisting between the parties, B, what it is that is in fact in dispute, and C, what it is that the referring party requires the adjudicator to determine.
Mm-hmm.
That altogether then determines what we call the threshold jurisdiction that an adjudicator necessarily has to have in order to proceed with the process.
And you've mentioned that a dispute has to have crystallized. What is crystallization in the context of adjudication? How do you say that a dispute has crystallized? What sets out that?
Adjudication is supposed to be speedy, cost-effective, and so-called rough and ready justice. The more accurate one is in delineating exactly what is in dispute, as I say, the less room there is to misunderstand and to avoid future problems with and issues around jurisdiction. The dispute crystallizes in a number of ways. So one can have a situation where a claim is made, an opinion is given, or something specific is done. and a specific response is given to that action, and that response then includes a rejection expressly. So you would say, I do not agree with, I dispute that, we do not accept A, B, and C. So that is ideally the way that you know that a dispute is crystallized. However, it's not always as simple as that. In instances where one party says nothing, that failure to react, that failure to either accept or reject or take a view itself could be enough for there to be a dispute crystallized.
Yeah.
So it very much again depends on the facts and the facts surrounding the particular dispute. But one of the things that a party, either or one or both parties in that situation need to be very clear on is what it is exactly that is being disputed.
Yeah.
And to dispute it in those words. And one thing that I find is that people tend to shy away from making those assertions. But to determine that a dispute has in fact crystallized, the best thing to do is to actually make sure that there is a dispute.
Mm-hmm.
In other words, pick your fight and understand what it is you're fighting.